the case on those grounds and explicitly relied on inference as to intentional delay of service of process. Although service of process was made within 90 days under Tennessee Rule of Civil Procedure 4.03, appellees waived their affirmative defenses as to service, and the trial court failed to convert appellees' motion to dismiss to a motion for summary judgment under Rule of Civil Procedure 12.03. Mr. Eskridge's surviving wife, Miss Dorothy Eskridge, timely filed the complaint on January 31st, 2018. The summonses were then issued by the Knox County Circuit Court the next day on February 1st, 2018. The summonses for the 5 appellees and copies of the complaint with the necessary hundreds of pages of attachments each were served within 90 days under Tennessee Rule of Civil Procedure 4.03, that is, on May 1st, 2018, without the need for issuance of any alias summonses. Appellees answered and attempted to raise insufficiency of service of process as an affirmative defense. However, appellees stated no facts to support the affirmative defense as required by Tennessee Rule of Civil Procedure 8.03 and Tennessee law. The answer stated, quote, "In further affirmative defense, it is denied that plaintiff properly served defendants in accordance with Rule 4 of the Tennessee Rules of Civil Procedure," end quote. To elicit the facts appellees relied upon under 8.03 in their attempt to raise the defense, appellant's former counsel served written discovery requesting such information, but none was provided in the appellee's responses. Further, the appellant's former counsel even wrote a letter, which is in the record, to appellee's counsel requesting the facts that appellees relied upon in their attempt to raise the defense. Still, after 3 opportunities, the appellees provided no facts. The appellant then moved to strike the affirmative defense in the trial court, and then almost immediately thereafter, appellees moved to dismiss for insufficiency of service of process and asserted for the first time appellant, quote, intentionally, unquote, delayed service of process. The trial court granted appellee's motion to dismiss, citing quote, reasonable inference that appellant intentionally delayed serving process rather than actual proof. Appellees waived their service defenses. Tennessee Rule of Civil Procedure 8.03 requires the party raising an affirmative defense to set forth facts in short and plain terms that they relied upon. That did not happen here. In the Pratchett case, which is a Tennessee Supreme Court case, the Tennessee Supreme Court held an affirmative defense must be specifically pleaded, and that Rule 8.03 clearly contains a specificity requirement. Appellees failed to raise any facts whatsoever in their attempt to raise insufficiency of service of process as an affirmative defense. Now, this case is similar to the circumstances in the case Milton versus Etizadi. That's a 2013 case of this court holding that Dr. Etizadi, I'm sorry if I'm mispronouncing that, waived his service defense by failing to comply with Rule 8.03 because his answer merely stated that he specifically pleads the defense of improper or lack of service of process. And then I think he pled after that he doesn't waive those defenses. That's exactly what the appellees did here, except to make it even more general, the appellees here vaguely cited Rule 4. But Rule 4 just defines service and service of process. It's a legal standard. The appellees didn't even cite which of the 9 subsections of Rule 4 they were relying upon in their attempt to raise the affirmative defense. This gives rise to no facts that the appellant could discern, and it certainly gave no facts in short and plain terms as required by 8.03.
I have 2 questions here. First of all, is it in the record as to why it took such long period from the filing to the service?
It is not, because the trial court, after the appellees moved to dismiss on insufficiency of service of process and claimed that the plaintiff appellant intentionally delayed, the trial court failed under Rule 12.03 to convert that to summary judgment proceedings. And so no proof was elicited by either side as to any intentionality, as to any reasoning, therefore.
Okay, and the next question I have is, when was the first pleading entered objecting to the service?
Well, it's appellant's position that that was waived, but the appellees answered on June 4th, 2018. And as I quoted earlier, very generally, very vaguely, with no facts supporting, tried to raise an affirmative defense. Now, once they first raised the intentionality, or that plaintiff intentionally delayed service of process, that was not until January of 2019. So that was some 7 months later that they finally, for the first time, said, okay, the appellant or the plaintiff intentionally delayed here.
Okay, thank you very much.
Of course. Any facts whatsoever, like I said, that the appellees relied upon to raise the defense were hidden until appellant was forced to move to strike the defense. The case law condemns this tactic. Insufficiency of service of process is an affirmative defense that required either appellees to move for summary judgment or for the trial court to convert the motion to dismiss to a motion for summary judgment under Rule 12.03. Appellee's motion was based on intentionality in the timing of service of process, which is clearly a matter outside the pleadings under Rule 12.03, and Rule 12.03 required the trial court to convert the motion to a motion for summary judgment, but the trial court failed to do so and dismissed anyway. The trial court respectfully, stunningly, made findings of fact in its dismissal order that were admittedly based on inference rather than actual proof that would have come out if summary judgment proceedings were had. The trial court could only make these findings by inference based on appellee's counsel's arguments and statements, which, as we all know, are not proof. The cases cited by the trial court to support such a conclusion, which these are cited in my brief as well, the Cox case, Estate of Butler, and the Vesu case, involve plaintiffs who admitted to intentionally delaying service of process for 9 and 11 months and for tactical advantage. Those scenarios are not similar to this case, as no proof of intentional delay was ever elicited, and the trial court found no tactical advantage to doing so. Either way, summary judgment proceedings were necessary, but the trial court was required by Rule 12.03 to convert appellee's motion to dismiss to one for summary judgment. This was clear error, and this court should reverse and remand.
Counsel, let me ask you. So, some purpose of the question that it wasn't waived, all right. And once they filed their motion, setting out the claiming, I guess, intentional delay under the rule, did you have any? Who had the burden? Did you have the burden, or the plaintiff had the burden to show it was not intentionally delayed, or did the defendant have the burden to show that it was intentionally delayed?
Well, the defendant had the burden at first to show that it was intentionally delayed, but then the trial court, like I said, should have converted over to summary judgment and given the opportunity under Rule 56 for the plaintiff at that point to say, hey, no, to answer a statement of material facts and to support their answer with affidavits under Rule 56 to say, hey, no, this wasn't intentionally delayed. But the trial court failed to do that. And my last point would be service process wasn't delayed or intentionally delayed. Rule 4.03 subsection 1 specifically allows for 90 days to serve process and does not differentiate between day 1 and day 90. No alias summons was ever issued in the case because none had to be. And there's no Tennessee case law that I could find or that appellees cite to support an argument that service made within 90 days may even be considered delayed, much less intentionally delayed. And appellant respectfully requests this court reverse the trial court's order dismissing appellant's case and remand the case for further proceedings.
Thank you. You have your time for rebuttal.
Thank you.
We'll hear from the appellee. You need to
I apologize. Here
That's
we go
all right.
again.
Sorry.
Rachel Hurt here as a member of the Knox County Bar here on behalf of all NHC appellees. Your Honors, listening to the argument just now, I think that there are three important dates to be aware of, and Ms. Guerrero has addressed two, and I want to address the third. The first date being the date that the complaint was filed, which is January 31st of 2018. The second date being May 1st of 2018, the date that the summonses and the complaints were served on all defendants' appellees. The third date, Your Honors, and going to the question of Judge McClarty, is January 4th of 2019. And this was the date, nearly 8 months after the complaint was filed, in which the returns of summons were filed in the trial court. And it was on that day, and with the filing of those returns of summons, that it became apparently and abundantly clear that plaintiff's counsel, prior counsel, individually and personally served the summonses on the registered agent 1 block from the courthouse. With that knowledge that there was only one attempt at service, with that fact that there was only one attempt of service by plaintiff's counsel 89 days after the fact, defendants now had sufficient and for the first time facts and knowledge that the first attempt or effort at service was 89 days. Within receipt and review of those documents, the motion to dismiss was filed 5 days later.
Why did you raise the defense in your answer then?
Yes, sir. I anticipated this question. I found myself to be in a catch-22 in preparing the answer. In my previous experiences with prior counsel, there were always games afoot. And I felt that there was something to the fact that there were 89 days when the court and the rules allow 90 days. I felt there was something there, but I didn't have facts. I didn't know if there had been attempts at service and they went to the wrong address. I didn't know if Knox County process server forgot. There were facts that I didn't have, but I didn't want to be in this catch-22 where I didn't raise anything. And then once and if I got facts, I filed it and then it's deemed waived because I didn't raise it in my first pleading. Or I put what I thought I knew at the time, that there was a delay and that under 12.024 and 5, this lawsuit there was not jurisdiction within the trial court and it was untimely pursuant to the statute of limitations. With hindsight, maybe I shouldn't have been trying to preserve that defense, but I felt that there was something going on. I just didn't have the facts. I'm not always the smartest to figure out what those are. As soon as I knew what the facts were, I filed a motion to dismiss within 5 days. Your Honor,
if you don't allege it at your initial appearance, do you waive it?
Well, Your Honor, the way that I have read 12.03 and the way that some trial courts have ruled on these issues, different jurisdictions do it different ways. Either I attempt to raise it and that's sufficient, and under the case law is you're supposed to interpret pleadings generally and to execute justice, or some judges say, no, you should have raised it the first day and we're not going to allow you to raise it later. And so I did what I did and asserted what I felt was appropriate based upon what I knew. To assert that an attorney has done something intentionally to violate a rule is a serious allegation and not something I would do lightly. And so I asserted what I knew and what the facts that I had at the time.
Okay. On your initial appearance, that you filed an answer to the complaint, a general answer to the complaint?
Yes, sir. And my initial responsive pleading was an answer to the entirety of the complaint, including raising various affirmative defenses. Yes, Your Honor.
Okay, thank you.
those are the dates. Plaintiff counsel wants to argue that I hid facts. There were no facts hidden here because all the facts were actually in the knowledge and control of plaintiff's prior attorneys. I did not know if attempts at service had been made. My clients did not know if attempts at service had been made. My clients would not know Attorney Rickman and who served. It was served through, not even my clients, but it was served through a registered agent for process. We did not have that knowledge until the return of summons was filed. When it was filed and we had that knowledge, we immediately filed a motion to dismiss. And I think it's significant that Rule 8.03, in the opinions of not only this court, but of the Supreme Court in addressing Rule 8.03, it talks about two criteria and factors for the significance of 8.03, and that is to avoid ambush and to allow the party to cure the deficiency. Here, with intentionally waiting 89 days to file the summons, there was no cure and there was no ambush. Once a delay of 89 days occurred, there was no cure to be had and therefore no prejudice. And so a narrow interpretation of 8.03 under the circumstances and for the public policy reasons for 803 do not apply in this case. Additionally, talking about prompt and contemporaneous, it's very clear in the argument here today by plaintiff's counsel and also in the brief that they take the position that day 1 or day 89 is prompt. Serving on day 1 or day 89 is contemporaneously with. And that is not what the rule provides. And as Judge Stevens accurately and appropriately held in the trial court, to make such a finding that day 1 and day 89 are the same and are prompt and contemporaneously with completely obliviates and guts the purpose of the rule and the language that it provides.
Well, let me ask you this. What facts did the trial judge have for her showing that the delay was intentional?
Well, Your Honor, I think the facts that the court relied upon were entirely within the court record and a judicial observation of distance. The facts is that the summons was issued on February 1st, and only 89 days later did plaintiff attorney personally deliver the summonses and the complaints to the registered agent 1 block from where the lawsuit was filed.
So that's the facts that the trial court used to determine that it was intentional.
Yes, Your Honor.
That there was apparently no service attempted, or at least as reflected, I guess, until day 89, and it was close by.
Yes, Your Honor, and both in the complaint and the summons, it was clearly and appropriately and properly identified the correct registered agent for service of process, so that information was known.
Maybe prior counsel was just negligent.
Well,
Would
Your
that
Honor,
be intentional?
and the intent is not taking any attempt or effort in 89 days.
Counsel, I understand. My question is, let's say the prior counsel, plaintiff's counsel, was negligent, put it under a stack and forgot to do it until the calendar tickled it, said, hey, 90 days is about to run. Would that qualify as intentional?
Your Honor, under the reading of the most recent case and following the 2016 advisory comments on prompt being contemporaneously with the complaint and summons, yes.
Now, okay, you're saying that then what does the word intentionally mean?
Intentional is to not, when you have the opportunity with the summons in your hand to, even if you walked from prior counsel's office, you could do it in 90 days.
I understand all about the distance and the time and everything.
You could put it in the mail.
Let me finish.
I'm sorry.
I know that's one of the drawbacks to this is overlapping talking, but I still don't understand how. I mean, do we assume that it was intentional because it was close by, service was close by, and only attempted one time and not until the 89th day?
Your Honor, I think the case law and the rule discuss effort, and because there was no effort, that is the intentionality.
Again, My question to you is, let's assume the plaintiff's prior lawyer was negligent, just flat out negligent, misplaced it, forgot about it, and then found it on the 89th day and served it. Does that qualify as intentional? Did they intentionally cause delay of the prompt issuance or prompt service of the summons?
Your Honor, I think if there had been an affidavit filed to that effect that say, I messed up.
Counsel?
Yes, sir.
It's really a simple question. I'm saying if the delay is caused by the negligence of the attorney, is that going to be intentional? Is that the same as intentionally delays it?
Okay. No, Your Honor. I think negligence would not be the same as intentional. But here there is no.
And does the trial court make an assumption one way or the other that the only possible cause for the delay because it was close by was intentional?
I think that when I filed my motion and asserted that it was an intentional, it became the burden of the plaintiff to prove otherwise and to submit an affidavit that said, I messed up, I put it at the bottom of the file, I was negligent, it was not intentional, could have been the burden that they could have shown, but they didn't. And so the inferences from what was before the trial court on my brief of intentionality because there was no effort is what the trial court found.
Okay, based on what?
Based upon
the trial court found there was no effort based on what facts?
Based upon the return of summons that showed that the plaintiff counsel only attempted once. The day he attempted, he was successful. He attempted on the 89th day. His signature was on the return of summons, and the discovery that also was served with the complaint and the summonses on May 1st was also dated May 1st, pre-typed and printed, showing an intention to serve all of those things on May 1st, which was the 89th day. That was the intentionality of the trial court, or the intentionality that the trial court found. And with no rebuttable or responsive evidence or proof by plaintiff counsel demonstrating that it was anything but intent, that's what the court found appropriately.
And the trial court's, the only facts the trial court based on that were facts contained in the record, I guess, that the trial, the location of the registered agent. And what was close to it? Was it the office of the prior counsel?
That was a factor. The office of the prior office of prior counsel was less than a mile from NHC Farragut. It could have been hand delivered to NHC Farragut faster than 89 days. It was.
Okay, so those are the two facts that the trial court relied on. The prior plaintiff's counsel's office was within a mile of the office of the registered agent service process, and the return showed that it was only attempted on the 89th day and it was successfully served.
I would flip the significance of those two, but it was the effort on the 89th day, Your Honor, I believe is what her order is very detailed and clear, but I believe that's what she placed the most emphasis on. That there was no effort or attempt before the 89th day.
Okay, and she assumed that was intentional.
I think that based upon what was before her and no response or no rebuttal of intent, which was the argument made by me, she was left with no choice. There was no other evidence to show that it was anything but intentional. There was no affidavit. There was no demonstration of effort or prior attempts at service. And
do you agree that, or whether or not a tactical advantage had to be obtained by the delay?
Respectfully, sir, based upon your concurrence in the Fuller opinion, no. And the term is used is perceived tactical advantage. There is not a requirement that it be present. Certainly, the Fuller opinion was just that there was a companion case. There is a companion case here, but a perceived tactical advantage under your analysis, no, sir, is not required. And is not anywhere mentioned in the rule itself or the advisory comments.
I was one of three, and that was my separate concurring.
Yes, sir, you were.
But if a tactical advantage is required, if it is, what was the perceived tactical advantage that the trial court had evidence before it showing a perceived tactical advantage?
Your Honor, I'll candidly state at the time that we argued this motion, the fuller opinion had not come out. A tactical advantage other than the ability to communicate with the nurses, trying to find and locate disgruntled nurses or prior employees, which is a common practice in nursing home litigation. That was the perceived tactical advantage, to be able to go out and gain evidence and experts before filing the lawsuit. That was discussed in the trial court.
And we're to assume that's so in every healthcare liability action, that if it's not served till the 89th day, we're to assume that there's a perceived tactical advantage.
Well, again, it's
waiting 89 days. I'm sorry, go ahead.
I'm sorry, I'm not trying to cut you off there. I think since it's a perceived and not an actual tactical advantage, again, once we raise it and assert it as a perceived tactical advantage, plaintiff has the opportunity to rebut the arguments that are, or the evidence that's being put forth before the court, the trial court.
Did your motion state, or did you raise any perceived tactical advantage? Say, here's the perceived tactical advantage from the delay.
Again, only when we discussed this issue in the trial court, it was attempting to delay the service of the lawsuit, to attempt to try to communicate with prior employees or even current employees before my clients were aware that the lawsuit was pending.
I mean, did you state that in your motion, that it was delayed in an attempt to communicate with prior employees?
Your Honor, I will not. I would probably say no, but I'm not 100% certain. It came up on question of Judge Stevens, is my recall.
All right. Okay.
I have exceeded my time unless there's anything further.
That's fine. I used most of your time.
That's okay, Your Honor. I appreciate it.
The appellant, we'll hear from the appellant rebuttal.
Thank you, Your Honor.
Counsel,
yes.
Why wasn't any affidavit filed saying this was not intentionally delayed?
Well, there are a couple of reasons. One, the appellees filed a motion to dismiss and not a motion for summary judgment. Had a motion for summary judgment been filed, certainly an affidavit, or maybe even more than one, I'm not sure, but would have been filed in response. Here, they went on a motion to dismiss. The trial court failed to convert that over under 12.03 to a motion for summary judgment. A motion to dismiss is on the pleadings. This is obviously outside the pleadings. The plaintiff at that time had no duty to respond, but responded to the motion to dismiss and said, hey, listen, this is for summary judgment. This needs to be converted over to summary judgment where we have a meaningful opportunity to respond. So,
did you ask the trial court to do that?
Yes.
The record shows that you asked that it be converted to a Rule 56 motion? Yes.
The response that former counsel filed to the motion to dismiss states very clearly this should be summary judgment. And I think that if I'm not mistaken, even the transcript of the hearing says this should be summary judgment. We're here on a motion to dismiss. This is constricted to the pleadings, and that was just never done. You can't assume that the service here was intentional. Such requires proof. Appellees assume no other attempt was made. We don't know that. I don't know that.
Well, what does the return of summons say?
The return of service, I believe the return of service just says, personally serve the registered agent, but unless I'm wrong, and perhaps I could be, filing a return does not have to lay out every single attempt that was made. Filing a return only has to talk about the successful attempt, about how it was served, how it was successfully served, hand delivery, certified mail, what have you. No summary judgment proceedings were had. We do not know, and that's why this court should reverse. The trial court, again, specifically found no tactical advantage, and the appellant's prior counsel specifically denied any tactical advantage would have been had at hearing. No tactical advantage was raised by appellees in the trial court either. The appellees never moved to amend their answer either. Even if they thought they could only plead the affirmative defense properly once the returns were filed, which I would argue were not necessary, then they should have moved to amend their answer to specifically plead their affirmative defenses, but they didn't do that. The plaintiffs are not required to solve a riddle or make a flow chart to try to discern what facts defendants are relying upon for their affirmative defenses.
Well, I mean, their motion set it out though, didn't they?
The motion 7 months later, that's not a pleading, that's a motion. They should have moved to amend their pleadings to conform with Rule 8.03. Appellees could have pled the date the complaint was filed, the date the summonses were issued, and the date of service, and alleged, perhaps by these facts, service was intentionally delayed. They didn't need the returns to plead those facts. They already had the summonses. Instead, they chose to plead no facts whatsoever in violation of Rule 8.03 in Tennessee law. And I think the appellees counsel talked about this a little bit and heavily relied on the Fuller case, this court's recent decision in Fuller, but Fuller is not similar to this case. The trial court in Fuller did what Rule 12.03 requires and converted the defendant's motion to dismiss for intentional delay of service of process to a motion for summary judgment. And Fuller failed to respond to provide affidavits in response to summary judgment under Rule 56. That's why Fuller lost. That didn't happen here. Appellant had no meaningful opportunity to respond under Rule 56 because the trial court failed to abide by Rule 12.03 and then dismissed anyway, assigning some assumptions and inference rather than actual proof. Respectfully, this court should reverse and remand the case for prior proceeding or for further proceedings, and we respectfully request the court do so. Thank you.
Thanks to counsel for both sides for your oral argument, and I apologize for talking over you. I think that's what was happening. Mr. Hibner, if you would, please recess court until the next case this afternoon.
This honorable court is now in recess until 1